employees, non-members of the same minority group, not suffer similar adverse employment actions. So the exceptions to Title VII, it's lawful to make employment decisions on the basis of national origin, religion, or gender if decisions are necessary for the normal operation of the business. So I guess an example would be if you are a exotic dancer and they only really need to hire women. Or another example of this would be if you work in obstetrics and gynecology for a primarily Muslim community, and therefore male nurses would probably not be utilized because of their sex or something like that. Promotions and layoffs may be based on a bona fide seniority or merit system. So constructive discharge, a person who resigns due to intolerable conditions caused by illegal acts of discrimination may file a claim of constructive discharge. Employee has to show that intolerable conditions were deliberately created to force resignation. So, for example, if you are an older nurse and they're trying to force you to resign before you retire, and you get moved, you could prove that they were trying to force it with constructive discharge. Maybe if they floated that nurse to a place that was just really hard for them to work or something like that. Federal tort claims. The Federal Tort Claims Act of 1946 was enacted to allow patients and persons with claims against federal workers to be able to sue the U.S. government. So an example of this is if you were to sue, if you worked for the post office and you were to sue your boss, this would be an example of a federal tort claim. Age Discrimination and Employment Act of 1967. It became illegal for employers, unions, and employment agencies to discriminate against men and women over the age of 40. So if you didn't get hired and you thought it was based on your age because you're over 40, you could sue them based on this. Showing age discrimination. So criteria for an age discrimination lawsuit, you have to be between the ages of 40 and 70. Perform job responsibilities according to employers' expectations. Be discharged, obviously, and be replaced by a substantially younger person. The Rehabilitation Act of 1973 promotes and expands employment opportunities in the public and private sectors for handicapped individuals. And then there's affirmative action, and it enhances employment opportunities of protected groups of people. United States Fair Labor Standards Act of 1938 established a national minimum wage and a time and a half for overtime in certain job classifications and prohibit child labor abuse. And then mandatory overtime, I think it mandates like certain amounts of overtime as well. So the national minimum wage came into play in 1938, and part of that too was to offer job fairness and job standards. Right now you can hear there's that term fight for 15. People are fighting for minimum wage to be raised to $15 an hour. And the minimum wage hasn't, I guess they're arguing it hasn't raised as quickly as inflation has. So when I was 14, I got my first job, and I think minimum wage was like $7.25, and now I think minimum wage is still like only $8.60, and that was 19 years ago. Go ahead, do the math. Oh no, 20 years ago if I was 14. So that's right, I'm 34. And so, think about how much the price of things has gone up. So, I remember milk was $1. And now milk is, close to $3. Equal Pay Act in 1963 makes it illegal to pay lower wages to employees of one gender. And as we know, that still kind of happens to this day. They just have to be careful with the wording. Occupational Safety and Health Act, so that's OSHA, 1970. It was enacted to ensure healthful and safe working conditions. And this came out after there was a bunch of textile workers who got, wow, by the way, you guys, minimum wage is still $7.25. That is insane. Okay. Sorry about that. Textile workers, I want to say, you know, at the dawn of labor unions many years ago, there had always been kind of a call to ensure workers' safety. And in the days of all this, there was a time where it was literally cheaper to replace a dead or injured worker than it was to introduce safety measures. But after the Civil War, there were some improvements made, especially, you know, when the railroad and factories got really big, and there was unions. They started to put into place some federal legislation. When mining got really big, there were so many people who were dying in the mines, and the United States actually started a Bureau of Mines to improve the safety. And then trade unions were able to enact workers' comp laws, which discourage employers from permitting unsafe workplaces. After World War II, you know, with the chemical revolution of stuff, there was all these new chemical compounds around manufacturing environments, so textile workers. And it got to the point where there was over 2 million people who were dead or disabled within like a 2-year period. And that's when they started talking about enacting more legislation, and it finally came to fruition in 1970. Employment at will. Historically, the employment relationship has been considered an at-will relationship. There's growing trend to restrict application of the at-will employment rule. So that's where we work, or that's how Ohio is. There's 3 exemptions to the rule: public policy exception, implied contracts, and the concept of wrongful discharge, and then good faith and fair dealing exceptions. Whistleblowing exception, when someone believes that public interest overrides the interest of the organization they serve and publicly exposes the organization for its involvement in corrupt, illegal, and fraudulent, harmful activity. Whistleblower law states that no employer can discharge, threaten, or discriminate against any employee because the employee acted in good faith and reported or caused to report a violation. The United States False Claims Act of 1986 protects individuals who are whistleblowers. Several criteria have to be met for successful whistleblower retaliation case. Oftentimes people get paid out for it. Wrongful discharge involves situations where there is implied contract. The purpose of good faith and fair dealing is to prevent unfair and malicious termination. So collective bargaining is the joining of employees for the purpose of increasing their ability to influence the employer and improve working conditions. That's like when you get together to form a union. The National Labor Relations Act protects collective bargaining, and it oversees the act and those who come under its auspices. The American Nursing Association supports the right of nurses to bargain collectively and represents the interests of nurses within the individual state, based on the premise of increased power and number and assists in basic economic issues, unfair arbitrary treatment. Based on the premise of increased power and number, assists in maintenance and promotion of professional practice. So there's good things about collective bargaining, especially when we talk about safe staffing. Criticisms of collective bargaining. So there's 3 issues: charges of unprofessionalism, unethical behavior, and imperiled job security. And what that means is like, okay, you're in a union, so it's hard to get fired. And I've seen places like that. And then I've worked for places that have a union, and you can get fired for negligence just as easily as if you weren't in a union. The National Labor Relations Act serves to prevent or remedy any violation of the labor laws. It ensures that employees can choose freely whether they want to be represented by a particular bargaining unit. ANA supports collective bargaining. So collective bargaining allows for achieving the basic elements of professional status, and collective bargaining allows a mechanism for nurses to resolve conflicts within the workplace setting. It enhances quality of care to patients. Organizing labor. Employers are not permitted to ban discussion about unions or retaliate against a worker trying to organize a union. And employers are obligated to provide names and addresses of workers who may be eligible. Workers can only distribute union information in non-work areas such as the cafeteria. Elections to unionize. The election is done by secret ballot, and more than 50% of the workers are for the union the organization is certified, and the employer is required to bargain with the organization. This is called the contract negotiation period.